Welcome, everybody, to the Myna Partners, Davis Wright Tremaine Insight Session. Important updates to the HIPAA security rule, what you should know about the recent notice of proposed rulemaking. My name is Dave Cohen. I'm a director here at Myna Partners, and I want to thank you for joining us, taking a little time out of your day if you're with us here live, and if you're listening to the recording, thanks for looking us up and spending some time with us. We're going to get started with the presentation in just a minute, but before we do, I wanted to let you know that we have a pretty healthy audience online with us live now, so we very much encourage questions. You'll notice that there's a comments section to the in your interface there, so feel free to post questions that you might have for us in there, and we'll try to get to as many as we can during the time that we have allotted for today, so we'll appreciate that. And a recording of this session will be posted shortly after the live event, and you can find that on the Myna Partners webpage if you're looking for it. We'll also post it on LinkedIn. So with that, without any further ado, I'd like to introduce the two guests we have for the program today. Corey Gant is one of my colleagues and a director here at Myna Partners. Corey, you want to talk a little bit about your Center of Excellence and Service Line here at Myna?
Sure. Thank you, Dave. It's really a pleasure to be here this morning talking with you and all of our viewers. As mentioned, I'm a director with Myna Partners in Myna's Cybersecurity and Compliance Center of Excellence, which is a sub-department of our practice. And as you can probably guess, we do a lot of work in the HIPAA space, assessments, against the security rule, the privacy rule, the breach notification rule. We also do quite a fair amount of remediation for any gaps or findings that we note in our assessments, as well as helping to implement process improvements that aren't necessarily gaps. And in addition to HIPAA, we also do a lot of other cyber and information security assessments and readiness assessments, such as the NIST CSF 2.0 framework, as well as ISO readiness and SOC 2 readiness.
Terrific. Thanks, Corey, and thanks for making some time today out of your busy project management day today. We appreciate you being with us. Also joining us for the conversation, Adam Greene is a partner with Davis Wright Tremaine. Adam works out of the Washington, D.C. office. And Adam, we're really pleased and thankful that you could join us. Really looking forward to hearing some of your insights about this. So can you tell us a little bit about the specifics of your practice and your background?
Sure. Thanks, Dave. Good morning, everyone. So my practice, I work with healthcare providers, health systems, some health plans, and a whole lot of technology companies and other types of business associates on compliance with health information privacy, security, breach response, information blocking, whether it be kind of proactive, working on policies and procedures, that sort of thing, day-to-day counseling on questions that arise, or the occasional oops of a complaint or a breach or something like that. I've been with Davis Wright Tremaine for about 13 years. Prior to that, I was at HHS, first in the Office of General Counsel and then the Office for Civil Rights, doing HIPAA over there. Back, for example, helping to implement the HITECH Act and bring some of the first enforcement actions back in the day, and work on essentially advising OCR on how HIPAA applies to health information technology and other new and emerging technologies.
Terrific. Thanks, Adam. And so that background was kind of why I reached out to you for some help with that long history with the agency and with HIPAA. So let's just go ahead and get right into it. So we got this announcement over the holidays. This is a notice of proposed rulemaking, NPRM, for those not familiar with it, which is basically the beginning of a process to update the rules of the security rule under HIPAA. So Adam, why now? It's been a long time. Do you have any thoughts about the timing of that and kind of, why this is happening now?
So, it has been a long time. I mean, the security rule was originally finalized in 2003 and really hasn't had any changes since 2003, other than an expansion to business associates and some minor tweaks back in 2013 or so. And when you look back at 2003, there was no iPhones yet.
Right.
Cloud computing was not really much of a thing. AI was strictly Terminator territory. I mean, the world was pretty different. And in the decades since, what we've seen is, one, the technology has changed dramatically. Two, the risk has changed dramatically. I'll talk about later security incidents, but the fact that the definition of security incidents includes every unsuccessful attempt, which back in 2003 maybe was a few, but now there's organizations may face millions of unsuccessful attempts a year. And so the risk has changed. OCR, the Office for Civil Rights, its experience with enforcing the rule has changed. And there's been a recognition that the industry is not where it should be with respect to cybersecurity. So, the Biden administration has had this on its to-do list and is trying to at least start the process for the administration changes to really try to both bring the level of information security up in the healthcare sector to better respond to the risks we're seeing today, and also improve the ability of OCR to enforce the security rule, because the level of flexibility has been godsent for many, but also makes it incredibly difficult to enforce, because for most things you have to prove that what a covered entity or business associate did was inherently unreasonable, for example.
Yeah, so therein lies the answer, actually. With the outgoing administration, with the new administration coming in, as you say, it has to have been on the desk and in the works for some time. So let's kind of get this out as one of the to-dos before the administration change. So that's helpful. We're going to talk a little bit more about OCR's role in enforcement and what that might look like, and how the process is going to play out in terms of finalizing the rules. But before we do, an understanding, Adam, that we don't have the time to kind of comprehensively digest the proposed draft rules. Can you talk a little bit about what jumped out to you as some of the most significant changes that are being proposed that might have an impact on organizations?
Sure. So, they've done away with addressable versus required implementation specifications. So everything is required. That is one general big area. I think there's a lot more annual requirements. So there's not a single annual requirement in the current security rule, whereas there's, by my count, 28 instances in the regulation of activities that have to be done on an annual basis, and even some that have to be done more regularly than that, like quarterly or monthly. The security rule has always been a big documentation lift, with the requirement to have very robust policies and procedures. There's now going to be even much more documentation. So documentation that you've reviewed your documentation that you've reviewed your controls, just a whole lot of documentation. I think some of the biggest pain points are going to be new requirements for technology asset inventory and network map. So kind of detailed listing of every technology asset, which is really any hardware or software that you have that interfaces with EPHI, Electronic Protected Health Information, which for a large organization is a Herculean task, I think, to put together. A network map, which once again, for a complex healthcare system, for example, is a huge challenge. So I think those are going to be some of the pain points. Some of the timing requirements, like terminating access within an hour of termination of employment, being able to restore all critical systems in an emergency within 72 hours, having backups no older than 48 hours. Some of those time requirements, I think, are going to be challenging. And then with respect to business associates, it's going to be challenging on both ends, that there's a requirement to collect a written verification from every business associate every 12 months that they have deployed all technical safeguards and conducted a written analysis that has been done. That's going to be a big burden on the upstream entities that have to collect them, and the downstream entities that actually have to respond to them. So those are, I think, some of the biggest lifts, and just a lot more detail. It's really bringing a whole, practically everyone up to what previously might have been considered more best practices.
Thanks, Adam. That makes a lot of sense. And Corey, I'm sure a lot of that resonates with you as we were talking about when we were doing the practice for the session here today. You were mentioning that hopefully some of these things, at least foundationally, are things that organizations have been paying attention to and do have in place. But certainly, it sounds like we've got some review, update, and Adam, as you said in the practice session, perhaps organizations have the actual controls in place, but they might not have the documentation down in terms of, documented procedures or, as you say, documents, that say that we've reviewed them and we've updated them regularly. So, Corey, kind of based on your years of experience with HIPAA assessments, what are you seeing as some of the major kind of priorities or things to focus on, or large lifts that organizations are going to have to comply with these rules, assuming they get formalized somewhat near to the way they're being proposed in draft right now?
Well, definitely would echo what Adam mentioned about documentation. It's interesting to note too that recently there was an update to the NIST CSF to version 2.0. A major change in that framework was the addition of an entirely new domain called governance, which relates to policies and procedures. So that's an industry trend, which I'm really happy to see that HIPAA is trying to align with the best practice framework, be it NIST but even ISO as well. So I think that's a change. When we perform assessments, we invariably have findings and gaps in the area of documentation. Another area of big impact, I think, is the risk analysis. It's not uncommon to have some type of finding in our assessments related to risk analysis. There is no time requirement around it. There's a periodic performance of it. So I think it's important that that kind of subjectivity be removed and there be a regular cadence for it. But also from the practical reason, if you take a look, I'm on the distribution list. Whenever there's a HIPAA settlement, I get the email blasted to my inbox. And anecdotally, it seems like 90+% of every settlement, the first bullet point in what the organization has to do is invariably around a risk analysis of some sort. Either they're not doing it and they should, or they're doing it and it's inadequate. So I believe that's going to have a major impact on organizations. And I think that kind of turning the screws on the risk analysis is going to have a big impact on the number and the severity of breaches.
Yeah, we see it across the board with organizations large and small that we work with here at Myna when people bring us in to help with these compliance obligations and these risk analyses. But ultimately, what we see again and again, what we find is that by identifying those gaps and tightening them up, you're also increasing the business operations, the efficiency of the business operations, and the security and the safety of the business operations. So I'm seeing, I wanted to just remind people that having some time here for questions, if people do have questions, if you could post them in the chat and we will try to handle those as we will. But Adam, but while we're kind of monitoring that, if you could let us know how the process is going to play out from here. So this was just a notice of proposed rulemaking that was just announced. There's going to be an open comment period, at which point OCR will then try to gather all those comments. And can you kind of talk us through and walk us through what that process looks like and do a little bit of crystal ball gazing in terms of when we potentially might see some finalized rules for those that aren't familiar with the process and having been in it even all those years before?
Sure. So comments are due March 7th, and we're expecting, I think, a lot of comments on this proposed rule. And then the $10 billion question, and I think that's the regulatory impact, what they think, but the industry thinks it's actually a lot bigger money attached to this, is will the new administration finalize this? And so, obviously, change of administration, change of views. And so many think that the idea of any Biden proposed rule being finalized under the new administration may be a long shot. But I think that this is pretty bipartisan. We under the prior Trump administration, while there were some policy changes with respect to HIPAA enforcement and a focus on good information security, we really didn't see a change there. We didn't see the past Trump administration miss a beat on that. So I think that there's a pretty good chance that despite potential unlikelihood in many other areas of finalizing Biden administration proposed rules, and despite the general tenor of an anti-regulatory administration, I think there's a pretty good chance that this will get finalized. Now, for timing, OCRs, I promise you, however many people you think work at OCR in headquarters, it's less than that. It's a pretty small, understaffed agency, and there's going to be a lot of comments. It's going to take them a lot of time to first review all the comments, organize them, and then really put together changes to the rule based on those comments. So I don't expect, I'd be beyond shocked to see it get finalized in 2025. I think 2026 is more realistic. 2027, 2028 is certainly not outside the realm. I mean, by way of precedent, I think for the HITECH Act 2009 statute, I think it was a 2010 proposed rule, and I think it was a January 2013 finalized rule. So, when it'll get finalized, it's probably going to be years, but it's probably going to take people that much time to get budget allocated to this and get their hands around this. So I think we need to take advantage of that time.
Well, Adam, that's a good, just kind of jumping off of that last point there. My mind was going to the same place, which is that even though there is some uncertainty as to whether it will even be finalized, but to your point, cybersecurity is unlikely to be dropping off the map of the next administration. And even, I mean, it's not the healthcare space, but I was just thinking about an article I was reading earlier about the infiltration of the major cell carriers and how significant that was, and the call, kind of unusual call out for tightening of cybersecurity controls to happen. That's probably a smart thing for organizations to do, is to assume that it will be finalized and to take into account these significant upgrades that will need to happen. And to your point, Adam, it takes a while for budget, and also for larger, more complex organizations with complex tech stacks and different divisions. This will not be a light lift, both the operational controls aspect of it and the documentation aspect of it. So probably wise, and certainly the smart and conservative thing to do, to be paying attention now to what these general requirements are likely to be, and then take steps, even initial steps forward with them. So thanks, Chris, for that question. And we get another great question just popped in. And Adam, maybe we'll stay with you just for a minute there. Do you have any thoughts about major issues, themes for the expected comments, even kind of what categories they might come in? I'm going to kind of start us off with one, which we talked about in the practice session, which is look, for some smaller mom and pop organizations or less resourced organizations, this is going to be possibly impossible, if they don't have the expertise or the staffing in-house to be able to help with these things, or the money to be able to contract out for it. So perhaps some carve out for, or exceptions, or somewhat lessened requirements for smaller organizations was one thing. But what are some other areas you think might be expected issues or themes for comments?
So I'm on a few groups that are working on comments. So I'll tell you the ones that I'm at least focused on. One would be encryption. I think their approach is a chainsaw where a scalpel is needed. So HHS, is proposing that all protected health information at rest and in transit must be encrypted, with very limited exceptions for just patient requests for access to their own records, for certain legacy systems, but where you have to have a migration plan to move towards an encrypted replacement, and certain things related to FDA. So, for example, in practice, if you're a doctor's office, if you're a hospital and you want to send a secure message, it starts off with an unencrypted email or text message that says, "Hi, this is your doctor's office. There's a secure message waiting for you on the portal." That, based on the way HHS has interpreted HIPAA in the past, that message saying you have a secure message is itself PHI, and really can't be done in an encrypted fashion via text message or unencrypted email. So I think we need to have a more nuanced look. I agree with the need for greater required encryption, but I think there's a lot of unintended consequences here if they don't take a more nuanced approach. I think we're going to get a lot of pushback on the inventory asset and the asset inventory, and the network map requirements. I think there's going to be pushback on the timing of 240 days. That's not even a budget cycle between when the rule is finalized and when you have to actually comply. To your point, scalability. I think OCR should take a risk-based approach. They generally take a risk-based approach with respect to the security rule, but they're now saying, here's dozens of requirements and you have to comply with all of them at the same time. So maybe we should have a staggered approach where, for example, compliance with things related to ransomware, much higher priority than, for example, increased requirements around maintenance records, which I don't think is at the top of anyone's list with respect to associated risks. So I'd like to see a multi-year, possibly staggered approach, especially with recognition of what's involved for small providers to come into compliance here.
Terrific. Corey, based on the kind of Adam's responses just now, and let's say organizations are saying, all right, we want to get a little ahead of the curve here. We're going to assume that these rules will actually at some point be formalized and finalized. What are some of the ways you've seen clients, in terms of the work that we've done for them, kind of prioritize these changes? Like, what are, just generally and roughly, what are some of the ways companies can even get started and just get going on trying to address some of these likely requirements that are going to be coming down the road?
Certainly. So I think the auditor/assessor in me would recommend starting with policies and procedures, right? I wouldn't want to see any of our clients implementing things operationally without having it emanate within policy, which ties back to the security rule. So before companies just jump off the cliff and start implementing, so I would like to see some planning, some strategy sessions internally, and maybe they can't implement, even if the security rule is implemented all at once, maybe they just can't do it all. So maybe they have to do some prioritization and risk assessment internally, and seeing, okay, what's a priority for us? What can we do? What do we have money for? Do we have the staff to do it? Doing that, starting with policies and procedures and some strategic planning and resource planning, and then knocking things out at a risk-based approach. Especially organizations that just don't have the money allocated or the headcount to do it. You can't boil the ocean at once. So I think practically, whether the OCR does it or not, it's gonna for a lot of organizations, it's gonna have to come in phases.
Well, that makes perfect sense, Corey. Taking a big picture, strategic, high level approach to start, and risk-based, and as you say, an audits and or assessments early on allows companies to phase out the work, to plan for the budget over time, and to take a kind of a strategic and measured approach. And by the way, you're also checking a box in terms of one of the upcoming requirements, which is likely to stay in, which is the annual assessments. So maybe you're already doing some work, some pre-work on getting ready for setting up who's going to take care of that. Where's the responsibility going to lie? Who's going to be involved? That's some bandwidth from staff that we need to account for, looking forward. So that makes a lot of good sense. Adam, back to you for a moment, and I know we're getting close to the bottom of the hour here, so we only have a few more minutes left. We have another great question. Curious about the chances for Congress to make some, what the questioner believes are overdue changes to the law itself. Any thoughts? Are you hearing anything? You're down there in DC. Any discussions or talks about updating the law itself?
Haven't heard it, but keep in mind HIPAA simply says HHS must create security standards. Mm-hmm. It really leaves it completely to the discretion of HHS. And the HITECH Act added a few specifics on the privacy side, but other than extending the security rule to business associates, didn't mess with that. And I don't know that there's an appetite on Congress to try to put into statute specific security requirements rather than continuing to leave it to HHS with essentially full discretion to HHS. So I'm not expecting anything with respect to information security on the congressional side. I think they're kind of happy with the model, and then they'll just, it's a lot easier to change regulation than to change legislation, to change statute. And I think Congress much prefers complaining to HHS that they're not doing a good job than taking it on themselves to actually come up with detailed requirements. The one area where I could see change here is the penalty structure. In the HITECH Act, Congress raised the penalties, but they did it in a very confusing, ambiguous way. And the Obama administration interpreted it one way, which essentially, regardless of your level of culpability, it was $1.5 million per calendar year for multiple violations of a provision. But then the last Trump administration changed that and said, no, it's these lower calendar year penalty tiers. And since that, and we've now more recently seen that in the past few HHS budgets, HHS has actually requested Congress to increase the penalties, really, I think, to, back the way it was interpreted under the first Obama administration. So the one area where I could see Congress acting is potentially clarifying and the penalties under HIPAA.
Well, speaking of penalties and enforcement, I wanted to get to that just to close in our final minutes here, to just have you talk a little bit about, Adam, how complaints are received and, what enforcements tend to look like. And I'd like to hear a little bit about that. But when you were just talking about the definition of the rules, it made me think of the Chevron decision. And I'm kind of wondering if you think that might have some effect here. Do you think that there could be some changes in terms of how the rules are interpreted by the courts when cases are actually brought?
A little bit. I mean, Chevron was focused, and the resulting Loper-Bright decision were focused on kind of regulations under the statute and the amount of deference given to such regulations, which is not really an issue here because Congress just said, go forth, do whatever you want with respect to security standards. So in that sense, I don't think it'll have an impact. But, similar to what we saw in a decision, MD Anderson, where court took a very strict reading of the security rule requirements and what it said and what it didn't say. I think we'll continue to see, and maybe even more so, very strict readings and by the courts. And essentially, HHS is trying to recognize that and put in more detailed requirements around not just putting in place policies and procedures, but really deploying the technology to try to get rid of any potential wiggle room so that the courts don't have that wiggle room to play with, essentially.
Yeah, that's helpful. And then just to finish out here, and I know we're just about out of time, how are complaints received just in general and enforcement actions? What kind of scale do they tend to be at, and just based on history?
So essentially, investigations tend to occur because there's a complaint, which could be a patient complaint or a plan member complaint, or it could be a whistleblower, for example. Another area would be media reports, which, like when we had journalists jumping into dumpsters and finding PHI there, that led to investigations. Another area would be breaches. But of course, that's a very biased view because it's those who report breaches then potentially get investigated and penalized, but it doesn't find those who don't report breaches, which it's almost impossible to find them other than whistleblowers.
Yeah.
And then there's an audit program, but that audit program, there was a phase 1 in 2011 or so. There was a phase 2 in 2016, 2017. We haven't had audits since then, and really much of the security rule, unless you report a breach or you have a whistleblower, is not visible to a regulator absent an audit. OCR has indicated this past year that they intended to start up the audit program again over the next year, but whether the new administration will take up that remains to be seen.
All right, terrific. Well, we're going to have to leave it there because we're out of time, unfortunately. But Adam, thank you so much for your time today. Really appreciate you making a little time to help discuss this. And obviously, we'll keep our eyes on it and monitor for developments. And I'm sure we'll be revisiting this at some point in the future. And Corey, thanks as well for taking a little time out of what I know is a busy project work day for you. I really appreciate you being here. As you can see on the bottom of the screen, we're providing some contact information for both Adam over at Davis, Wright, Tremaine, and for Corey and myself here at Myna Partners. And I want to thank everybody for joining us, and I hope you found some useful information in the program today. With that, I'll go ahead and take us to a program close. Have a great rest of the day, night, evening. Everybody, take care.
Thank you.
Thanks.